Hello, everyone. Thank you, Sylvia, and welcome to the fourth part in our Cybersecurity Webinar Series. Today's session, we're going to be talking about data governance and contract management and how you can build security into your contracts. For those of you that have joined us for some of our prior sessions, in our first session, we went over the importance of understanding some of the cybersecurity challenges within your legal vendor community and portfolio. We then talked a little bit, my colleagues Shay and Ryan talked a little bit about cybersecurity benchmarking. We took a particular look at one of the methods for externally assessing your legal vendors quite quickly and efficiently to get a really good handle on the exposure of your cybersecurity risk across your portfolio. And then last week, we had our friends from Prudential Financial join us and really share some of their wisdom about building a legal vendor cyber risk program for their organization and some of the progress that they've been able to make. So hopefully everyone found that useful. And today I'm going to be passing over to my colleagues, Tyler and Derek. We're going to really talk about how some organizations can leverage transferring risk through their contract management process to really set the right expectations for their vendors and also ensure that they have the necessary terms in place to assist them in the event of a breach and so on and so forth. So with that being said, I'll make some quick introductions to Tyler and to Derek. So Tyler joins us from our legal management consulting practice. He has over 15 years of experience, particularly in legal operations, contract management, and mergers and acquisitions. Prior to joining Duff and Phelps, Tyler was a VP of operations for a global intellectual property firm, and he has a Bachelor of Science from the University of Oregon and a JD from the University of St. Thomas. He's a licensed attorney in Minnesota. So welcome, Tyler. Looking forward to hearing from you. And then we also have Derek Mihm. He's a senior manager also in our legal management consulting practice, and he assists Tyler and specializes in the contract management space, particularly in data governance. He graduated from the University of Minnesota. He's a magna cum laude from Minnesota University Law School. And he was also at a global intellectual property firm prior to joining Duff and Phelps back in 2016. So with that, I'll hand over to these guys and look forward to hearing some of their experience and how we can deal with this issue through contracts.
Thank you very much, Imran. I appreciate the introduction. Derek, can you advance one slide, please? So, Imran, or Sylvia, I don't know if you want to speak to this slide. Otherwise, we can jump into our introductions.
Yeah, no, I think we can jump through. I think really the focus of this session is really, again, on the hows we can implement some of these strategies, particularly in the spirit of contracts that we may have with our third-party vendors, particularly law firms.
Great. One more, Derek. One more, Derek. Perfect. So where we wanted to start was just a very, very, very quick overview of who Duff and Phelps is. While Derek and I are taking you through our story arc, we're going to be talking about some of the other things that Duff and Phelps can provide because it creates a more thorough and deeper experience for our risk management services. Just to kind of show you our global depth and breadth. 3,500 professionals, a global firm that has over 55 service lines, most of which involve risk and governance and the mitigation of such. Next slide, Derek. So particularly, Derek and my focus is in contracts. As Imran expressed, we're both practicing attorneys. We come from a legal background. Contracts have been in our life for a very long time. And some of the services that we offer kind of led us to this risk landscaping and risk mitigation service suite. So contract review, database, it's a general information governance suite. And the more that we got into contracts, particularly in the drafting and negotiation, the more we realized that contracts were coming from so many different directions into companies' portfolios, whether it's through acquisition, or otherwise. And while all of these groups are coming in, some of the most important aspects of a contract are what you know about the vendors. what risk do they bring to the table? And so what we're going to be talking about today, Derek, next slide, is a story arc that involves how you mitigate risk in contracts and how you leverage your contracts to help mitigate the risk that that company brings to your portfolio or to your table. So our presentation today is going to be broken up into 3 chunks. The first chunk is, what do you want to put in your contracts? What are some standard provisions that will help you on the onset mitigate risk? They may be negotiated away. They may need changes based on certain parameters of the engagement. But at the onset, we have seen these to be the most, and we'll talk about types, the most effective types of provisions. The second part is about an info security structure. And particularly what we're going to drive at there is how you assess the risk of the vendor or the counterparty. And when you're assessing that risk, you're going to begin to see cracks that risk has created in their structure. And it's how you then use contracts as the sand to fill in those cracks. So we'll talk about kind of a streamlined info security structure and how that leads to a rapid response in contracts to help ameliorate risk. And then finally, Derek's going to talk about actual rapid response and how contracts can help to create a risk landscape, something that our clients in procurement particularly like to use. So that's the general story arc. We'll talk a lot about our experience. We'll talk a lot about some of the services that we have, not as a sales pitch, but more as a, you should think about these things. There are plenty of vendors that do it. We happen to think we do it the best, but it's really just something to keep on your radar as we discuss these topics. So Derek's going to take the first part. I'm going to take the second part, and Derek will bring it home with the third part. So Derek, I will turn it over to you.
Thank you. So moving on to our first topic, what types of clauses and what language should you be including in your security, data security provisions? There aren't going to be any explicit examples of contract language that we're going to be presenting. We don't want to make hard recommendations during this presentation because we wouldn't want you to rely on just what we're saying during this talk. But we are going to recommend a long-form essay that was published just this month, actually, that has a really strong example security addenda that I think covers the topic really well. So I think we'll post a link to it in the chat when we get to that point. Okay, so there are really two main categories of clauses that you need to have to cover off on your risk as effectively as you can. And the first category of clauses are precautionary clauses. That's what actual steps do you require that vendor to take to prove that they are going to be able to prevent a breach of some kind from happening. So in those clauses, you're going to want to include what level of security you require. And most likely this is going to align with the level of security that you employ at your own organization. So the creation of an information security program that is written down that you can analyze, identification of any encryption requirements that you might have for the data that's being passed from you to that firm. If you have differing levels of data that have higher or lower sensitivity, perhaps by category, what level of encryption those types of data require. It might include a requirement to conduct background checks on any employees who are going to have access to that data and what specifically those background checks need to be, category by category. You probably want to include some form of language regarding physical safeguards for the actual storage devices for that data. So the location that the data is stored in needs to have keyed access. The entrances need to be covered by cameras. Only specific personnel can be allowed into that area, those types of things. So then the next subcategory of clauses are restrictions on storage. How can the data be stored? And this can be both a physical restriction, meaning where physically is the data located, on-premises requirements, offshoring restrictions, or even extremely specific, it can be only be accessed from a specific office location that the firm has and only by specific people in that office. And then that can also include restrictions on the type of storage that they are allowed to use. Potentially don't want them to be moving any of that data onto local drives on a local machine. It should only be accessed through a secure shared drive that's held in a data center, and never move to a thumb drive, for example. It might require that it never be provided to any sort of cloud service if it's a third-party data center. And that leads to the third category of clause types, limitations on access. So who, for example, only those individuals who have a need to use the data and only for the purposes for which the data was provided. Depending on the type of data, there are other common restrictions on access. So like de-identification requirements or anonymization requirements. And some of these things are essentially dictated by statute. So depending on what type of data we're talking about, all of those things need to be covered off on. And then finally, as a precautionary measure, clauses that require your providers to stay up to date, to keep up with best practices in the industry. So generally, two forms of this. One, a requirement that they evaluate their own security measures on a regular basis. And then two, further including an audit provision that gives you the right to look at their information security program and make a determination whether you feel that they are keeping up with best practices in that arena. So in this clause category, precautionary clauses, you're probably hearing a lot of similarities between what you would include as precautionary clauses in a data security program and what you would include in a general confidentiality provision. And I think you could make the argument that a well-crafted confidentiality provision that includes some of these above and beyond provisions and above and beyond language could theoretically cover off on your data security risk. And I think from an academic perspective, that's probably true. But I think we would strongly caution against conflating those two concepts, because having worked in contracts for long enough, I think confidentiality language is generally considered boilerplate and is practically ignored. And I think that that's of particularly high risk when it comes to legal services providers, because the professional rules of conduct that attorneys are subject to require confidentiality. And so I think there's an assumption on the part of many attorneys that by default, they are doing enough to protect your data just based on what practices they already employ. And so we would pretty strongly recommend that those data security precautionary clauses be shifted out of the confidentiality provision, at least be given their own section in an engagement letter, and ideally probably be included as a separate addenda, and perhaps even with its own set of signature blocks, just to ensure that everyone understands this is a very serious requirement. We take it seriously, and so should you. Okay. I don't understand what I just did. There we go. The second category of clauses are incident response clauses. So what, in the event of a breach, what is it that you require that vendor to do? So you are going to want them to agree to have a written incident response plan, because the last thing that you want is for them to be scrambling after a breach, trying to figure out what they should be doing instead of actually doing the thing that's going to prevent damage. Second, you're going to want a clause that very specifically lays out what notification you expect, the timing of that notification, as ideally a number of hours. This is personal opinion, probably I should stray away from this, but immediate and prompt don't mean anything necessarily. So a firm commitment on as soon as they know about how much time do they have to get back to you, and then the contents of what that notification need to include. And you're probably going to want to include specific provisions for, what type of data was breached, who was it about, what tranches of data, if it's split into chunks, were affected, and then give you a contact person at that provider to keep you apprised of what's going on. And then finally, some form of indemnification, reimbursement, limitation, or liability language covering off on this specific scenario. And I'm sure this is not surprising to anybody that you might not recognize the damages from a breach for years potentially after it's occurred. So it's better to know, I think, what your exposure, how much of your exposure is potentially going to be covered ahead of time, rather than have that be one more thing that you're worrying about while responding to a breach. So I did mention a couple slides back that we have, we recommend an essay that was just published by the Sedona conference. I think when I'm going to pass the next few slides over to Tyler, and I'll move this link into the chat. You take a look at that. It is freely available for individuals to use, and I think there is potentially a small fee for reprinting on a commercial basis. So I'll move that into the chat, and Tyler, I will pass it back to you.
Thank you, Derek. So one more slide, please. So Derek has spent a good amount of time on the proactive specific clauses that you should incorporate on a go-forward basis. I'm going to spend a little bit of time on the reactive nature of info security models and how those should inform your contracts. So most companies, most firms have a standard Infosec procedure that looks similar to what we've outlined up top. There are obviously more complicated risk assessments out there, but generally we suggest that you at least have what we've put up top. And what we're going to show you here is that what we see with most of our clients when we get there is that they have a model that assesses risk, and that's fine. But the problem is that it gets you only so far. The assessments themselves don't actually get into the specific questions and the specific nature that will inform the contract. And what that ends up doing is slowing the process down. So instead of asking about your information governance practices, perhaps you should ask about the specific practices that would lead to informing provisions in your contracts. So it's just another level. And yes, it does make it a bit more cumbersome for the counterparty, particularly those that aren't going to be awarded the business, but there are procedures and there are tools at your disposal that you can use to help with maybe the uniform submission of an info security questionnaire. Next slide, please, Derek. So what we're going to do first is we're going to have a poll. So what we'd like to get a pulse on is just how robust, if at all, you and your firms have as far as an info security model or questionnaire. So as you can see, what we're trying to gauge is your level of maturity with the model. So if you'd like to submit, that would be fantastic. And I will give you just a second to read those and submit, and then we can move on from here. Actually, while you're reading it, I'll talk just a little bit more. So what we have found also is that a lot of the info security models that we come across, they actually aren't reviewed. Sometimes they're just a formality. And as Derek mentioned earlier, that can lead to some very, very damaging events. Not every firm is perfect, obviously, and not every firm will be breached. Not every firm will have kind of ill practices when it comes to your data. And as lawyers, we're trained that you don't have to worry about the 99% that don't have problems. You've got to worry about the 1% that do. Okay, results are back in. So it looks like we have some pretty good and mature models. We do come across some firms that have limitations. They have large gaps. They allow some firms to come in quite quickly, quite freely. It looks like a good majority does have one, but equally,
if I may jump in. So the
Yeah.
answers are 38% said to the question, does your organization employ a standardized InfoSec review during vendor onboarding? 38% said yes, and it applies to all vendors, including law firms and other legal service providers. 15% said yes, but it does not apply to law firms or legal. Another 38% said yes, but it is not universally applied to all vendors. That is, there are spend level exceptions or vendor type exceptions. And then 8% said we do not have a standardized review.
Thank you, Sylvia. So it's actually in that second 38% that I want to discuss. So Derek, will you move to the next slide, please? So I'll hold the poll results until the next slide. But what we're presenting here is that in a reactive manner, what we advise our clients to be doing is having a standard matrix of riders that apply to different answers in the info security response. And so what we're trying to help our clients do is speed up the process and to mitigate risk in the same breath. So what we have set up for some clients is, depending on how the questionnaires are answered, you then know that certain riders apply. If they have, if they're not ISO compliant, then maybe rider B and D apply. If they have locations in countries that don't have or have high risk because you're moving physical product, then riders D and E apply. So what we're trying to do is create a cocktail, in essence, that they can apply after the questionnaires come back. So now we're giving you the reactive contract security that you need. Because as I mentioned before, the only way, well, not the only, but the best way to mitigate against the risk that you unearth during these questionnaires is with your contract. It's the sand that fills in the cracks that the risk has exposed. And so, we help them create these riders. It's a very time-intensive process, but it has been extremely effective. And where this is very effective is for our clients who are serial acquirers. Those clients that are acquiring a lot of companies every year, one of the things we advise on is the first thing you have to do is you have to take a look at who your vendors are and what risk did they just bring into the walls of your company. And that can be done in several different ways. One of the things that Duff and Phelps has is a third-party risk assessment. We can actually do assessments on the physical locations of all the vendors. We can do an assessment on the contracts that those vendors have with additional parties. There are various things that you can do to assess risk, not just within the language of the contract. And so by doing that with all of these newly acquired contracts, and that's something that Derek's going to talk about with risk landscaping, you in essence are helping mitigate the risk that you just purchased. The other thing that we help clients do, and it's not just with the InfoSec questionnaires, it's actually with the review of the contract. Again, something that Derek's going to talk about in the next section. Let's go through those contracts and first, let's help our clients understand what is the perfect contract that you want to go out the door with. It's going to have all of those proactive contract clauses. And then let's assess the contracts that have been executed with the acquired party and their vendors. Let's see what it's missing from that perfect contract that we have created, and then disseminate or dispatch those riders that help fill in those gaps. So, we're kind of describing that there's several different ways to mitigate risk. There's several different ways to look at risk. It's the contract and the vendor itself. Derek, next slide, please. So the final slide that I'll be talking about is just really kind of the pitfalls, and it has a lot to do with timing, which is why we've been focusing a lot on the efficiencies of the procurement process, the info security process as well. So there are ways to kind of help speed that up or pull things forward, which is having vendors to voluntarily adopt the stringent addenda, which is obviously a very difficult thing to do. Typically, this is left to the largest of our clients because they have the most muscle. But even then, sometimes you get two Goliaths that are trying to battle out contractually, and there's just no room for movement. The other thing is to have a standardized questionnaire. Clients like to use portfolio projects that help them standardize the submission. A company like Cybersecurity 360 might have a universal submission so that you can submit once and it applies to many different clients. The other thing that's not listed here, which we like to talk about, is having a risk portfolio examination. And that would apply to that second 38% that was polled. So it doesn't apply to everybody, but it has thresholds. And sometimes you can examine where risk is coming from. And if you can do enough examination and have enough data about where your risk is coming from, then you can actually move forward with higher or lower risk profiles for your info security. And that's something that we help our clients design. But in the interest of time, I'm going to let Derek take back over for part 3 so that we give enough time for Q&A at the end. So Derek, I'll pass it back to you.
Thank you. So we're going to move to our third topic, which is a retrospective approach to risk mitigation using contracts. The sort of standard Infosec model that most everyone is using, according to the poll, is great to cover off on new vendors, but there's always going to be, well, not always, but commonly, there are going to be scenarios in which you don't have that risk covered off on through that standard process. And so we have a proposed solution for that we are going to present. Okay, so what are the most common scenarios in which you would end up with risky relationships that are not covered off on proactively through the information security review and the matching of a security addenda to that risk profile? The first, existing agreements that either predate the InfoSec review or perhaps rogue contractors within your organization. And those might be people who have the authority to enter into contracts despite not following policy if they're high enough in the hierarchy, or it might just be people who wanted something bad enough that they found a way to skirt the edges of the policy and get that service procured despite not technically having the authority. The second category, and I think the category to which this service is most likely to apply, is the acquisition of contracts. When you are gaining a large number of relationships through an acquisition or a merger with another similar department with similar overlapping responsibilities, who was not as sophisticated potentially as your organization is when it comes to mitigating data security risk. And then finally, the third common scenario would be changes in scope. If you are engaging, for example, a boutique law firm to handle a specific matter for you, but they really knock it out of the park repeatedly, and you decide, you know, it's just simpler to expand our engagement with an existing vendor than it is to find a new firm to handle some larger matter. But the information security review that was done on that firm doesn't match to the new data that's going to be involved in this larger matter. It's not that you don't trust them, it's just it wasn't handled ahead of time. And so now you're stuck with a mismatch between the level of risk and the security rider that you have attached to that engagement. So those are the three common scenarios. Any of them might be true. If you're like most organizations, you probably don't have 100% visibility into every contract that you've entered into. And even if you do have a centralized repository, a contract management system that's used for all relevant contracts, it's unlikely that the metadata is 100% up to date, especially with regard to, for instance, what rider is attached to those contracts and which data security provisions are actually included. So it's not necessarily easy to look at all of your contracts simultaneously and say, do we actually have a security provision rider sufficient to cover off on the risk that's associated with this vendor? So there is a solution, artificial intelligence and contract analytics. So there are a lot of people throwing around the terms artificial intelligence and machine learning in all sorts of arenas. I think in the realm of contracts, it's particularly troublesome because contract data is by its nature unstructured. We're generally talking about data, information stored as an image, PDF, TIFF, and the application of artificial intelligence is pretty limited when it comes to image analysis. So we need a combination of optical character recognition to make old contracts, or I mean current contracts realistically, if there's paper signed and scanned, into usable data that an AI engine could use. So there are a number of vendors in this space. There's the Seal Softwares, the Kiras, the eBrevias, the Evisorts of the world that all have similar models, and they all basically have the same suite of capabilities, which are listed here. The actual strength of those capabilities is going to differ depending on which AI engine you're talking about. But for the most part, they're going to have these things, and these are the three capabilities that are relevant to the solution that we would propose for risk retrospectives. So the first is fuzzy text searching, which functions basically the same way that you would expect it to function in any other arena. Some of them have more robust fuzzy text searching and have, you know, a whole suite of Boolean text operators that you can use, and some of them are really just, you know, show me where data security appears in this contract, and use common analogs for those words. The second capability are pre-trained data models. So a data model in this context is a conceptual clause in a contract. So document name, parties, effective dates, term, assignability. And the analogy that I like to throw out for this, for any of the audience that's familiar with, for example, Westlaw or LexisNexis, it's basically building a really long search term with, for example, you know, is this language more relevant if terminate appears within 5 words of anniversary? Then it's likely to be a term provision. And then each one of those is assigned a correlation coefficient, and that's how it decides whether or not the sentence or paragraph that you're looking at is relevant to the concept that you are looking for in that data model. I think this is where the biggest range in vendors exists. How many pre-trained data models they have and how good those pre-trained data models are can vary pretty extremely between vendors. And because this is so close to many of the services that Tyler and I offer, we try very hard to stay abreast of current developments and take a look at all the vendors in this space on a regular basis. So we have recommendations, I guess. I won't go into it right now, but if you're curious, you can definitely talk to us about it. And then the third capability is bespoke training. So those out-of-the-box pre-trained data models are only going to take you so far. You need, for this service, to be able to expand on those and include new concepts. And so a lot of these engines will allow you to simply highlight text in a document that you've uploaded, tell it what it corresponds to, and that's how the machine learning engine picks up on new concepts. So those are the three things that we're going to touch on. A little bit more about how the AI functions. It's using 3 types of AI. First, clause extraction, locate the relevant language based on that algorithm that I mentioned. 2, point extraction, from within the relevant language, pick out discrete data points. So in this below example, this is from a contract that was publicly filed with the SEC, so there's no confidentiality concerns there. It might be looking into this term paragraph and pull out the discrete point that there's a 60-day written notice termination for convenience in 3B. And then 3, inferences. The engine might be capable of knowing that because this term paragraph is the only relevant language that it found in this hypothetical, and it doesn't contain anything resembling a fixed term, an auto-renewing term, any sort of options to renew, that this is in fact a active until terminated or perpetual contract. So that's how the engines function. And now on to the real meat of this. How do you use those capabilities to determine risk retrospectively? So one, it's incredible how many processes can be reduced to 4 steps if you really want to, and if that's the graphic that you have. So here we see a 4-step process to get this done. The first thing that you'll need to do is generate a vendor list. As I'm talking about this, I'm going to use the hypothetical that this is an acquisition and we don't know who all of the vendors are. So you would feed all of the contracts that you acquire into one of these engines and use the out-of-the-box data model to produce a list of every party that is in one of those contracts. Almost all of the engines are pretty good at this. It's obviously relevant to almost any scenario that you would want to use one of those engines for, so they can all pretty much handle it. That is the list that you're going to then use to start crossing off names as once you've identified that they do actually have risk mitigation language. And that takes us to step 2. You are going to use the engine to come up with a list of search hits on commonly used terms within data security language. And you're going to use any out-of-the-box data models that touch on the concepts of data risk. So if they have a HIPAA detection model, if they have a GDPR detection model, if they have a California privacy law model that exists, you're going to pull out all of that information. And from that, you can generate a matrix of every contract that hits on one of these terms and extracts one of these clauses and which parties they're associated with. There's a step 2.5 here, which is you need to actually evaluate those hits and those extractions. And the reason you need to do that is that every data set is going to have some unique pitfalls. For example, we performed a data risk evaluation for an acquisition made by one of our clients, and the search terms, which seem like they should be relevant, GDPR and data security, were actually negatively correlated with the presence of a security rider. And the reason is that GDPR, for whatever reason, was a common garbled text result of the optical character recognition process. And for the most part, they were leases. And so it was picking up too often on the concept of like a security deposit close to the word data. And so when you have results like that, you need to reevaluate those search hits, generate a correlation coefficient. The likelihood that one of those search hits or clause extractions actually means that a data security rider is present in that document, and then reevaluate that model and potentially perform step 2 again, factoring in what you've learned during the first pass. When you've finished with that, you're going to begin bespoke training on your own riders. And the reason that we would recommend that you wait until you already have those risk markers is that you may not know how closely the language of the acquired company matches to the concepts that you're trying to control for. And if you start training a bespoke model to cover off on some of those clause types that we talked about earlier, you're going to be overly limiting the engine's ability to detect close matches. So then you'll, at this point, you'll do that and you'll be adding that to your matrix. And once that matrix is complete, from the search term hits, the out-of-the-box data model hits, and any bespoke training that you're able to do on your own language, you're going to have a pretty good picture of how likely it is that any given contract from the data set contains language that is analogous to your language, that it contains data security terms of any type, and you can use that to cross-reference against your vendor list. So that's step 3. That rating on the contracts of how likely they are to contain data security terms and how closely they match to your own riders is going to tell you whether or not you should feel comfortable classifying that relationship overall as low risk. And if you don't feel comfortable classifying that relationship as low risk, you should have a pretty good idea of which vendors need to be repapered. And depending on how long that list is and how risky overall you feel the data set of that acquired entity might be, you might take the time to investigate further on those vendors and see if there is some sort of mitigation in place, or find out exactly what data they have access to and go back to that risk matching scenario from the proactive model. Or if it's time sensitive, it might just be prudent to repaper everyone that you aren't sure about with a letter amendment and see who pushes back. So that's the quick and dirty version of this. The actual exercise of coming up with that matrix is unique to each data set, but it can be done relatively quickly because it's really not a human intensive exercise. You're leaning very heavily on the strength of the artificial intelligence engine. So we are rapidly approaching the end of this, and we do want to leave time for questions. So I think at this point,